My name is Deisy Hernandez. I am a assistant state attorney under my elected official, Catherine Fernandez-Rundle. We here in Miami are a population of 6 million, so real small, tight-knit community, right? We have a office of about 1,200 individuals. 200 are assistant state attorneys. And one of the things that we kind of panicked early on in the pandemic is we have about 15,000 cases at any time pending in our jurisdiction. So we could lose no time. And unfortunately, in our jurisdiction, we only had one rule that allowed for proceedings to be done remotely, which was the first appearance hearings. And we had no infrastructure set up in the courthouse for these proceedings. So it took us a little while, about 4 weeks, to get set up. And we worked collaboratively as a community. You know, the state attorney's office donated webcams for the jails. We donated laptops, you know, to the clerks. We did all kinds of things together so we can have this set up to begin in April, our remote proceedings, which we're currently still working on. We actually start our in-person proceedings on the 28th. We're all very excited to get back together. But one of the things that has come up early on in this transition period is we have to keep some of this Zoom. Some of the practical reasons are is we don't have enough parking in our area. We have, you know, very quick hearings, and we have litigants who have to come to court and they can't miss a day of work, things of that nature. So when I became chief of operations, Ms. Rundle then said, right in March of last year, and guess what? You're in charge of setting all these procedures in motions. So this is something that's been on my mind for quite some time. And now as we move forward, we're really working through the issues. So the first thing you have to consider is, in your jurisdiction, do you have any statutes or criminal rules that allow for it, that authorize these procedures? As I indicated, in Florida, the only procedure that we were allowed to do electronically was the defendant's appearance at his first appearance hearing, his bond hearing. The Florida Supreme Court right away had to promulgate procedural rules to allow for remote proceedings, signing, you know, things like indictments and informations electronically, swearing witnesses in electronically, all these things that we all took for granted needed to be authorized by rule. And as soon as our Supreme Court order is expired, they're going to have to start actually drafting statutes and rules if this is something that will be a future endeavor. One of the things, interestingly, that we struggled with in the beginning is, does the defendant have to waive the right to an in-person hearing? And in the beginning, the defense actually was very adamant about the need for waiver, and they really didn't want to do a lot remotely, even the simple stuff. And now what we find interesting is it's the defense bar, especially the private defense bar, that wants to save the parking money. They want to come and, you know, it's more convenient for them to appear by Zoom than come down to the courthouse for maybe, you know, a quick 5-minute motion to continue. The thing that was lost in the beginning of this is, should the state have to consent to these proceedings? We didn't get asked very often if this was something that we wanted to be a part of, you know, and in the end, when we realized this was going to be a long-term thing, obviously, we just all kind of did it. But now when they want to do these hybrid of, you know, morning in-person calendars and afternoon Zoom calendars to accommodate the defense bar, what if I want to come in and handle my case in person because maybe for some practical reason I was already in the courthouse for the morning session? Am I supposed to be now Zooming in from the hallway because defense counsel doesn't want to come down? So we're struggling with that issue because there seems to be this sense of, oh no, you're just right across the way. You can just, you know, run back and forth from court to your office and don't worry about the inconvenience in the, you know, Miami 96-degree sun. Other things to consider is, again, the ability to sign documents electronically. In Florida pre-pandemic, the only electronic documentation system we had was the discovery. The paperwork back and forth, we were permitted to sign electronically, but things like indictments, informations, the judge's digital score sheets, none of those things were accounted for. So again, the Supreme Court had to promulgate an order, which is still in effect, But if this is something we're going to be doing in the long term, they're going to have to create new rules, promulgate new rules. Finally, in terms of substantive procedural considerations, how do we serve defendants with documents? In our jurisdiction, if the defendant has access and can provide us an email, we've been doing it that way. Sometimes if they don't have access, the defense counsel, public defender will accept service on their behalf. And we even created a small window of opportunity where you can come down to the courthouse, and if there's absolutely something that needs to be done in person, like pick up a document, we've been doing that. For example, the probation violation, probation pleas. We've made they take their pleas remotely, but we say as a condition of your probation, you're going to have to come down to the courthouse and give us your fingerprints. That's how we track the cases. So that's something that you may have to consider in terms of probation cases. Let's talk about some of the practical considerations. This is the one we're struggling with here in Miami right now. How do you balance the in-person versus Zoom proceedings? In our jurisdiction, we'll have, let's say, a 9 o'clock morning calendar, and then they want to set a 9:30 Zoom calendar. Well, I can promise you here in Miami, where we all love to talk, there is no calendar finishing in half an hour. So the question becomes, how do we accommodate the litigants who are already in the courthouse and who may have a Zoom matter? Are they going to all be in the hallway on their cell phones Zooming? That could come, with some really unprofessional appearances. So we're trying to really figure out how we're going to balance what we're doing in person with what we can do via Zoom. This is something that our courthouse was lacking, the ability to have enough Wi-Fi bandwidth. Fortunately, the courthouse did hire some extra staff. They do have IT support now, and they've increased the bandwidth throughout the courthouse. And most importantly, because in this pandemic, we all went paperless. So we're all going to have our laptops where, the state's going to have its caseload on a laptop, the public defenders as well. People are going to be on their cell phones. So that was really important and something they've been working on to make sure that we don't have the, traditional connectivity issues that we all had in the beginning, that we couldn't even hear each other. The other thing to consider under practical considerations is if the lawyers and the judge and the clerks are in person, can incarcerated defendants continue to appear remotely? This is something that our Department of Corrections has been asking. The budget in our jurisdiction for transporting inmates, you can imagine that with our huge caseloads, is quite large. We also have various jails facilities. We have one jail that's across the way, but we have the main jail that is away from the courthouse, and then we have sub jails. So they very much want to, continue this idea of defendants maybe not coming to the courthouse and appearing remotely. The problem is, as you know, there's no real hybrid for Zoom. So if we're all in the courtroom and the defendant is at the jail with a laptop in front of him, is it all going to be recorded right? What's the audio going to look like? Is our record going to be properly protected? So these are things to consider if you're trying to maybe limit the defendants that are in custody from coming in the courtroom. And finally, under the practical considerations to think of is, should the use of remote proceedings be subject to veto by any party? Again, that's back to, are the defendants going to be waiving this? Should the state consent? Should we have our access to these public courtrooms if we choose to, just because we choose to, no other reason, even if it's less convenient? Those are decisions that will have to be talked about as we progress. And finally, some communication considerations. My pet peeve in this whole pandemic has been, court lost its significance, its seriousness. We've all been the victim of people appearing, driving their cars. We've seen people in their t-shirts and shorts. I've seen defense attorneys literally in bed addressing the court. I've heard defense attorneys, oh, I can't turn my camera on because I fill in the blank. I mean, there's been a lack of, demeanor and professionalism, I think, at least in our jurisdiction, sadly, because it's you know, you're behind this one-dimensional screen, and it's very easy to take some shortcuts. An interesting thing I've also found is that people have, you know, I had a defense attorney in the emergency room with his child trying to do a Zoom hearing. That would never happen in the old days. You'd call the judicial assistant and say, you know, I'm unavailable, please reset my case. So we have to think, is this ability to Zoom in going to create this, you know, need to Zoom in when we may have something more pressing going on in our personal lives, for example? How can defense attorneys communicate with their client? We all love breakout rooms. What we have found in our jurisdiction is because of the ability to breakout rooms, there's less communication before court with defendant and counsel, because before they'd maybe meet 5 minutes early, they'd chat in the hallway. All of that is gone. So fortunately, our jail system in this 15 months has upgraded and have done a video conferencing communication with attorney and clients, which has been very successful, and I think is going to help move a lot of our business around, because visiting our jail is not as convenient. This is something we all struggled with and will continue to struggle with, is how does the public communicate and participate in the proceedings? As we all know, our courtrooms are public and we can't limit the people's ability to come. And what we did in our jurisdiction is we posted everywhere you can imagine the Zoom IDs. We made it public. We did not password protect anything. And if you continue to do these Zoom hearings, you will have to continue to keep the community informed if you want to come and observe court and participate in it. You know, this is the opportunity you have. And, you know, the downside to that is every once in a while you'd have some inappropriate contact, you know, seeping its way through court. But that's a hazard with the necessity to keep it a public courtroom.
I'm sorry to interrupt, just about 5 minutes left.
Thank you. This is my last slide. We also have to think about how the court reporters are going to be in our proceedings. So we switched to electronic audio court reporting, and then if you order a transcript, it will get transcribed afterwards. That was a necessity out of the pandemic. And can courts create standardized methodology for these proceedings? We are trying to in our courtroom, and what I've found is every judge wants to create their own schedule. So it's been a little challenging really understanding, you know, what day you're going to be in person and what day you're Zooming. I'm hoping that as the weeks progress, we'll kind of figure that out a little bit and we can keep some uniformity in what we choose to keep on Zoom and how we organize our schedules. Just a little snapshot of the kind of things we've been doing here in Miami-Dade County. As Shannon talked about, the idea of doing pre-files, we are reactionary as well. We have arrests, we bring in our witnesses. These are kind of some of the numbers of witnesses that we've met with in order to file our cases. Police officers, we've discussed and talked about probable cause. We've been very busy, as you can tell. Our office went entirely paperless. Fortunately, we had been starting the practice. Nobody wanted to rip that final Band-Aid off because as lawyers, we all love our paper, but this made it necessary, and which was a smooth transition because our database had already been started. And what's interesting here, which is something I think we're definitely going to keep, is the ability to do depositions remotely. In our jurisdiction, unlike many others, part of the discovery process is each listed witness is brought in for a sworn statement by the defense. If it's a defense witness, listed witness, the state obviously brings them in. The ability to do this remotely and not having people miss entire days of work, coming down to the courthouse to do these sworn statements has been very convenient. The only caveat is if it's a civilian, I think those are the type of proceedings maybe you want to still keep in person because it's much easier to judge someone's credibility in person, obviously, than on this one-dimensional screen. So in conclusion, I think it's obvious that this will be a permanent part of our system moving forward. I do think that if we think about it in advance, what's effective and what's not, it's going to be a very useful resource for us moving forward as a system. And we are hoping to have a successful June 28th. Thank you, everybody.